everyone. Welcome to the show, Keeping the Peace. I'm Vince Velasquez, retired detective. And joining me today is our guest today is retired detective Kirk Burkhalter, attorney, retired NYPD detective, law professor, man of many talents. Welcome to the show.
Pleasure to be here, Vince. How are you?
Thank you. Very good. So yesterday, as we know, the Minnesota AG has announced that he's upgraded the charges against Officer Derek Chauvin to second-degree murder, and has also arrested and charged the other three officers for aiding and abetting in second-degree murder. So let's take a look.
Has there been any effort on your part of the William County Police Department to also seize Mr. Arbery's cell phone to do some testing or looking on his phone?
I did. I explored that option. At the time of the shooting incident, Mr. Arbery did not have a cell phone. It had been broken. Apparently, according to his family, during his runs, he would often drop his cell phone and it would break. And the last time he broke it, his mother said, "I'm not buying any more phone." And he continued to break it later.
In investigating, I'm going to go back and pick up a couple of things that may be a little out of order. In investigating the incidences that were ongoing in the Satilla Shores neighborhood, there was an incident on January 1st, 2020, where a car was...
Is it because I'm still on, guys? Do I need to leave?
Mr. McMichael's car. It was another car where another gun had been stolen. Are you aware of that?
I am not. No, sir.
Where the fingerprints were taken from that car?
I am not aware of that.
Did you become aware of Officer Rash's involvement with the Glenn County Police Department, or speak to him about, or have one of your agents speak to him about his trying to assist the Satilla Shores neighborhood with the burglaries and break-ins?
I did, yes. Or I had one of my agents interview him, yes, sir.
Did you learn anything from him that you felt was concerning about the neighbors' efforts or the McMichael's efforts to solve the crime issue in their neighborhood? What did you learn from him? Keep it simple.
I believe he had written a report. The way his statement to the agent was that he was familiar with the ongoing trespassing issue, that Greg McMichael had interacted with Greg McMichael. Greg McMichael told him to pass along a message to Larry English that if he saw the guy in the house again, that he'd always call Greg McMichael and provide his number. So Officer Rash did that.
So Officer Rash encouraged Larry English to call Greg McMichael?
No, sir. Officer Rash said he was just passing along the message, was his interpretation. Mr. English, though, did not see the message until after the shooting incident had occurred. He just had missed the text messages that had run through. So according to his statement.
Okay. The warrants that you took for Mr. Travis McMichael.
Cancel. This is your last question. If you were taking much break.
Yes, sir. This is the end. Thank you. Well, maybe more than one question, but this is the end. I was just going to ask him about the warrants he took.
Oh, go ahead.
Okay, thank you. The warrants that you took, one was for aggravated assault. The basis, the factual basis of the aggravated assault, what are the specific facts that we discussed that you are saying this is the aggravated assault, that is the aggravated assault here of this count number one?
my specific fact that I based on one
Yeah.
that I provided, it would be that the aggravated assault occurred when Travis McMichael pointed a 12-gauge Remington 870 shotgun at Ahmaud Arbery.
Okay, when he pointed the firearm, and you described that as when he was standing next to his truck, and Mr. Arbery was running towards him, and he held the gun up like this when he was saying, "Stop, and get down."
That is one instance, and then Travis McMichael indicates he was pointing the shotgun at Ahmaud Arbery as he was approaching him at the front of the truck as well.
Okay, and that would be the basis of the aggravated assault. The
Correct.
pointing of the firearm as he was running towards him, and he was yelling, "Stop," or when he came around the front of the truck at him, and he pointed the gun at him after he came around the front of the truck at Travis.
That's correct. After Travis went around the front of the truck, yes, sir, that's
And
correct.
Mr. Arbery came around the front of the
That's
truck
correct.
at Travis. Travis points the gun. That's the aggravated assault at that moment.
And when Mr. Arbery was 30 to 40 yards away and Travis was pointing.
Okay, so now we have a distance. So 30 or 40 yards away.
That's according to Travis McMichael's
Fair.
statement.
Fair. And at the same time, he was 30, 40 yards away. Travis was saying, "Stop, stop, get on the ground."
That's my understanding of his statement.
Gotcha. And then the document that you created simply states that the offense being described as the accused pointed and discharged a shotgun, which is a deadly weapon capable of causing death or serious bodily injury, at Ahmaud Arbery. This statement is the sum total of what you presented to the signing magistrate. Is that correct?
That's presented to a Superior Court judge and no offered oral testimony in reference to this
So
case.
you're saying you actually gave oral testimony in addition to what you made in your affidavit.
That's correct, yes.
And where is that oral testimony reflected? Is it been written down now? Is it on a document?
No, sir, I provided to the judge.
The judge himself, if he were sitting in this witness stand, would say, "Yes, I got additional information outside of the four corners of this document."
I'm sure he would, yes.
You're sure? Okay. Now, moving to the felony murder that caused the death, obviously, Mr. Arbery was shot and killed on that day. And so
Yes.
the basis is what exactly? That he was shot and killed that day?
During the commission of a felony to aggravated assault.
And it being the pointing of the gun as he was approaching and the pointing of him as he came around the front of the car.
That's correct, yes.
I don't have anything further. I appreciate your patience with me.
All right, we'll be in recess until 2:15.
Thank you.
All rise. Maybe it is.
All right, so of course it's Bryan Buckmire, not Vincent here, but we just saw the end of that preliminary hearing. I know that we have Professor Burkhart with us. Professor, the last few questions are really trying to get to the elements of the crime. What do you think was made of those last questions?
So, there wasn't anything so damning on the part of the defense there, and a lot of what we know already. So it seemed like we had this, what was established was the position, the relative positions of the defendant and the victim. This goes hand in hand with what we heard earlier, right? So this kind of started with McMichael's testimony, or statements rather, that he could tell from 30 or 40 yards away, based on his prior Coast Guard training, that Mr. Arbery was not going to comply. So every action that was taken after that seemed to fall in line with his belief that this person was committing a crime and that he wasn't going to comply. So this coming from around the car and the shotgun blast and so forth. So it's nothing that we didn't expect already. I certainly don't see there any lack of probable cause on the part of the state to charge the McMichaels as the result of what we've seen so far in the hearing.
Okay. Now, Professor, it might have been Travis McMichael who did the shooting, but we know that Gregory McMichael has the prior history with being a part of the police department in that area, as well as with the district attorney's office. It seems that they're trying to use some sort of police tactics because they're trying to make a citizen's arrest. If we're going to compare those actions to what the police are trained to do or authorized to do, would that even be good enough to say, hey, police officers would have done the exact same thing, so therefore I'm innocent because I'm making a citizen's arrest?
I would have to say no. And I think that you could get a litany of law enforcement officials and folks with law enforcement experience to state that that is a textbook way to not arrest someone. First of all, the use of deadly physical force where there was clearly, or there was no indication that any force was going to be used against them to effect the arrest. So that's the starting point there. Most law enforcement officials don't walk around with shotguns. They have other firearms, but certainly that's the starting point. And there really didn't seem to be, just judging from the video alone, and also the testimony of the defendants, you didn't hear a lot about an attempt to take Arbery into custody. The only thing you heard was this presumption that Arbery was not going to go quietly. So this is kind of a textbook example of what not to do. Certainly, at that point, they didn't have probable cause, from my opinion, to believe that Arbery committed a crime. So at best, this would have warranted some type of investigation or questioning and so forth from a law enforcement perspective. Certainly, when conducting a citizen arrest, citizens don't have the right to detain and question others, except for narrow instances. And as we've discussed plenty of times, certainly department store security personnel have the right to stop and detain someone. But the average person doesn't have the right to stop and detain someone and question them, even if they're in front of their home walking by and that you're suspicious. So once again, kind of a textbook case of what not to do from a law enforcement perspective.
Exactly. You hear it there, what not to do from a law enforcement perspective. We're going to take a quick break and come back with more the Ahmaud Arbery case in the preliminary hearing. All right, so it's Bryan Buckmire again. What we're going to do is we're going to take a little bit of a break from the Ahmaud Arbery hearing because currently they are on lunch break. They said they'll be back at about 2:15, and when they do come back, Law&Crime has got you there. Let's instead take a step back and look at a different case, the George Floyd case, because yesterday they came out with increased charges for former Officer Chauvin, as well as officers being charged on aiding and abetting towards that murder in the second degree. Let's take a listen.
That based on our review of court records that have just posted, all three officers that were seen on that video have now been charged. We're talking about J. Alexander Kuhn, Thomas Lane, and Tu Tao. Court records indicate have been charged with aiding and abetting second-degree murder. Now, based also on those court documents, we see that the fourth officer, who had previously been charged with third-degree murder, we're talking about Derek Chauvin, court records indicate that his charge has now been elevated to second-degree murder. So we can confirm that according to court records here from the state of Minnesota, all four officers, Brooke, that were involved in this incident involving the death of George Floyd have been charged by authorities.
All right, Professor, I am so glad to have you here because this question, I think, is really going to be well answered by you based on your plethora of background in different areas. I see why they moved from murder 3 to murder 2. I understand the aiding and abetting. But every time I see murder 1, I look at the premeditation and the intent, and I understand that it might be a hard bar to reach at trial. I think it's enough for the grand jury. And I always think about when I was a kid wrestling with my cousins. You play the wrestling and you choke hold them and you tap out if you were going to get close to passing out. And you always had that one stubborn cousin who wouldn't tap out and they passed out. We all knew once a person passed out, if it got to that point, you had to let go. Because if you continue to hold their throat, they're going to die. So tell me how that 2 minutes and 53 seconds is not premeditation and intent by Officer Chauvin's part when he does that to George Floyd. That doesn't make sense to me. Can you make sense of that?
But I think you hit the nail absolutely on the head. And this has to do with the difference in standard between probable cause, whether a reasonable person would believe, and beyond a reasonable doubt, right, which lives somewhere well into the high 90 percentile. And I think that's what the prosecution was concerned about. Not would they be able to sustain preliminary hearings, such as we just saw here in the Arbery case, preliminary hearing to determine whether or not there's probable cause to make an arrest, but whether or not they would be able to sustain a conviction. So certainly, as you point out, and I think the time factor is key. as far as intent. The former police officer there put the defendant with his knee on his neck for the 8 or 9 minutes. That in and of itself, right? While Mr. Floyd is screaming for his life or pleading for his life, and he then starts to fade out of the picture. That shows two things. Tends to show intent, and it tends to show that this was a premeditated act, just by virtue of the fact that the former police officer, had time to get up, had time to think about this and reflect. When we talk about premeditation, quite often we are talking about reflection, the amount of time it takes for me to weigh my actions and then make a determination that I am going to act. So certainly here, I think that there certainly would have been probable cause to charge him with this. And I do believe the prosecution was very concerned about being able to carry the ball across the goal line, so to speak. Could you imagine, and not that this should be political by any means, but reality is prosecutors are political figures. Could you imagine the ramifications if the prosecution charged this former police officer with murder one and they were unable to prove it? So like I said, perhaps that shouldn't be a consideration, but that's a reality.
I hear you on that, but in my mind, like any of my clients, what they do is they charge you with the top charge they believe they can carry past the grand jury, and all of the lesser included. I actually think that it goes to the point that they're not being political, or that they're being truly servants. They say, hey, what we're going to do is we're going to present the facts with the strongest one we think we can get for the grand jury. Murder one, murder two, murder three. If we present them as best as we can, but the jury, the community, our peers say, you know what, prosecution, I know you went for the strongest one you can get an indictment for, but we as a community believe murder three, that makes more sense to me, other than you're like, you know what, we could have done one or two, but we're just going to come with the lowest murder possible. When I see that for police officers and not for individuals, that raises questions. And I'm saying, what are we doing with this criminal justice system?
Yeah, I was actually surprised, not that the felony murder subdivision of murder two is not that it's inappropriate. However, when I first heard murder two, I assumed, the prosecution is still going to proceed on with intentional murder. So I was quite surprised that they went for the felony murder subdivision, like you said, which is completely appropriate. However, prosecutors have the latitude to charge in the alternative. We say this person is guilty of this. However, if you don't find they are guilty of this, we can argue that they also are guilty of this particular crime. And back to your original point, folks on this show, many commentators have argued that there are inherent problems, and this is not to pile on the prosecutor of Minnesota. He's doing an incredible job in difficult circumstances. However, there are inherent problems when our prosecutors are elected officials, because that has to factor into some of the decision making. I would argue, had the defendant here not been a police officer and this occurred and we had video of this, yes, we would see murder one, murder two, murder three. I have no doubt.
Good. Now, the death of George Floyd, obviously, as we're experiencing now, led to a lot of protests, not only in this country, but abroad. Let's take a look at some of those protests. All right, Professor, so those are the two videos, and I'll just break it down really quickly, because when I saw these videos, the first one broke my heart in a sense, but also then got me very angry, because that, I think at least, is the heart of why George Floyd died. We're all saying, why couldn't one of those officers tell this guy, hey, man, he's down, he's passed out, he's out? And I think it comes down to sometimes the pressure to work in one line or one accordance rather than other. In the first video, we see an officer take a knee in solidarity with the protesters, who are very peaceful at that time. Professor, before I move on to the other video, I see it as, hey, he should do it. It doesn't seem like it's interfering with his ability to regulate the protesters. Is there something I'm missing as to why that's wrong and why his fellow officers literally ripped him off his knee to stop?
I think that's an individual decision for that officer, whether that officer should take a knee or not. I can't criticize him on his actions so long as he is performing his duty. One thing, I've been involved in more demonstrations than I would like to remember. I stood there with a helmet on and my baton and so forth. And my father, who's a retired sergeant with the police department, always reminded me that when people view me, when people say something to me and I'm in uniform, they're not saying it to Kirk Burkhalter. That was not who they were addressing. At that particular time, I was a visual extension of the government. And these folks are exercising their right to speak to the government. Now, I tended to and act accordingly. I would not chastise another police officer for kneeling unless he was compromising his safety or the safety of another. But that's me. That's my individual opinion. And as you noted, we have to remember in this day and age, optics. And the optics of what law enforcement does quite often is very important.
I absolutely agree with you there. And we didn't get a chance to go to the second video, but of course, that's horrible. Officers shooting outside the window. That's why they're protesting. That's why we're out in the streets. We'll be back with more the protests and justice for peace after this break.